Merci, Monsieur le Président. C'est un honneur.
Thank you, Mr. Speaker. It's an honor for me today to take the floor to discuss Bill C-13. This is a sad moment because here we have before us a bill with all kinds of shortcomings.
I want to also put on the record that I regret the Speaker's decision. I understand the Speaker's reasoning, but I would have fully supported the request by the Honourable Member for Esquimalt, Juan de Fuca, for that amendment to be selected. That is an important issue of gender identity and ending discrimination, and I think it's a shame that we missed the opportunity today to have that amendment before the House of Commons. What we're looking at here, and the point was well made just moments ago by my honourable colleague from Charlottetown, is a terrible shame that this bill wasn't divided. There is no doubt that easy passage would have greeted a bill that genuinely dealt with cyberbullying and did not once again resurface efforts at what's called lawful access, but which is generally known in common parlance as internet snooping by the state into the private lives of Canadians. There are many troubling aspects on the internet snooping or lawful access part of this bill that have bedeviled the part that we all would want to support to genuinely deal with cyberbullying. So my comments will be in relation to those portions that should have been split out, dealt with separately, and not brought forward as though there's nothing wrong with them. And those are those sections that relate to so-called lawful access. Those sections that deal with the release of private information and private communications of Canadians under much less stringent circumstances than in the past, contrary to what the Minister of Justice said just moments ago, is very worrying. Had it not been worrying, we wouldn't have seen such strong statements from various of our privacy commissioners, our Federal Privacy Commissioner, Jennifer Stoddart, the Ontario Privacy Commissioner, Commissioner Kavokian. Many privacy experts have spoken out that this bill will, as have so many other bills that have been put forward by the Conservative administration, violate our charter rights, certainly violate our privacy rights. We've seen the Canadian Bar Association, the Criminal Lawyers Association speak out strongly that sections of this bill with modest changes could be made acceptable. But those changes were all shot down in committee. This is a case where, as Member of Parliament for Saanich Gulf Islands and as leader of the Green Party, I was invited, I suppose is the right term, coerced might be the one that comes to mind more often, by the new process that applies to members in my position, those with fewer than 12 members of their party in the House or independents, with 48 hours notice to get before various different committees. I brought, I think it was a dozen or so amendments on C-13 forward to the committee on this issue to try to deal with those sections that we would now ask for deletions. We would like to see this bill improved even now at report stage. Unfortunately, all our arguments were shot down and all the amendments were defeated. In short form, I'll just cover the basic themes of what we find, and of course some of these themes have been well touched on by the Honourable Member for Gatineau in her quite strong explanation of what's wrong with this bill. The provisions that allow for the telecom companies' involuntary disclosure of private information to be held harmless against any subsequent prosecutions. These are unnecessary. It's in fact, we now have as well the decision in Spencer, which has been referenced as well this morning, or rather this afternoon, that make it clear that this bill is out of step with the Supreme Court. We don't need to make it easier for telecom companies to voluntarily turn information over without a warrant and without some of the protections that we used to see in other descriptions of when such information could be turned over. So the fact that we can see various levels of public officials ask for such information is worrying in and of itself. The fact that they can do it voluntarily and be immune from prosecution is a further worry that we will have significantly more invasions of privacy in the guise of doing something about cyberbullying. The second area of concern, Mr. Speaker, is that of the lack of accountability and oversight. We used to require that, police would have to have reasonable belief, reasons to suspect, rather, and now it's a watered-down provision. We need to have more oversight. When we are dealing with issues of privacy, and in this Internet age, goodness knows we're more aware than ever that private information of Canadians, the kinds of things that we used to keep in our homes under lock and key, a stranger would have to knock down the doors and go rifle through your cabinets to get the things that now, through technological breakthroughs in the Internet, are easily accessible by the state through the simple process of pressuring the telecom to release this information to us. This is a significant threat to privacy rights in Canada. Should this bill pass as currently before us, and if it goes, it will be a significant violation. It will lead inevitably to violations of privacy rights of Canadians. Now, the other piece that's been widely criticized in this bill is that the scope of public officers who can have access to this information has become too broad. Now, I know it was something of a spoof, but it was certainly a telling way to make the point that public officers, and this was an opinion piece that ran in the National Post. Justin Ling has a good sense of humor on May 4th of 2014, pointing out that the list of public officers who could have unprecedented access to private information of Canadians would extend to the current mayor of Toronto. Now, while we certainly are dealing with a personal tragedy in his life and hope nothing but the best for his health and recovery, the point is made. We do not want to have the private information of Canadians so widely accessible to such a broad group of individuals. Of course, it also would include CSEC, the Communication Security Establishment Canada. It would also include CSIS, as well as public officers of all kinds, including mayors. This is not the kind of oversight, accountability, and control that Canadians would come to expect when the apparatus of the state decides to make it, to reduce the tests and lower the threshold on having access to the private information of Canadians. Mr. Speaker, I want to ask, and we'll certainly have debate on this. I know that the honourable member, who is now Minister of Justice, will have defences and say that it absolutely doesn't reduce privacy rights. I'd put it to him, why then do so many privacy commissioners think it does? If it doesn't intrude on civil liberties, then why do the major law organizations, legal scholars in this country, say that it does? But I ask the Conservative members of Parliament on the other side of this place, where they draw their ideological wellspring, I think, from a very large distrust of the state. There are a lot of members of Parliament on the other side of this place who describe themselves in their own conversations as libertarians, who distrust the state, who distrust government reaching into their private lives. And I ask them, how have they gotten so far from a distrust of the state to a cult of Big Brother? I'm really wondering how it happened that we've moved from a nanny state to a Big Brother state, in which if the government wants this information about Canadians, those of us on this side of the House who want to defend privacy rights are somehow siding with, as a former minister in this place once said, and now he's a former, I can mention him, when Vic Taves said, you stand with us or you stand with the child pornographers, are we to continue to hear that when we stand for privacy rights of Canadians, we don't care enough about ending cyberbullying? It's not too late to still split this bill, allow us on the opposition benches to strongly support the measures that will protect the vulnerable from cyberbullying. But please, let's draw the line at letting Big Brother have more access to private information. This bill goes too far, and they know it. Thank you, Mr. Speaker.
Questions and comments? Questions and commentaires. The Honourable Parliamentary Secretary to the Minister of Justice.
Well, thank you, Mr. Speaker, and I thank the member for her speech. She mentioned in her speech that she thinks this bill should be split into two pieces, one being the very specific criminal provision having to do with the non-consensual distribution of intimate images, and then everything else, i.e. any investigative power, in a separate bill. First of all, I didn't hear from her say what additional witnesses she thinks should come before the committee, since the committee had very extensive hearings on this issue, and my colleagues on the opposite side who are on the Justice Committee will confirm that. And secondly, I wonder if she's read the CCSO Cybercrime Working Group report on cyberbullying and non-consensual distribution of intimate images, and in particular, recommendation 4 of that report, which says the working group recommends that the investigative powers contained in the criminal code be modernized, and that these amendments should include, among others, data preservation demands and orders, new production orders to trace a specified communication, new warrants and production orders for transmission data, improving judicial oversight while enhancing efficiencies in relations to authorizations, warrants, and orders, and other amendments to existing offenses and investigative powers that will assist in the investigation of cyberbullying and other crimes that implicate electronic evidence. How can she stand here and say that we don't need these investigative powers in order to prevent the next Rehtaeh Parsons or Amanda Todd case from happening? And I'd like to know if she agrees with recommendation 4 or if she disagrees with any of the parts of recommendation 4. Thank you, Mr. Speaker.
The honourable member for Saanich, Gulf Islands.
Mr. Speaker, I thank the Honourable Parliamentary Secretary for his question. I think we know that the criminal code contains a lot of the measures we need for investigating cybercrimes. The current criminal code contains the following: that for greater certainty, no production order is necessary for a peace officer or officer enforcing or administering this or any other act of Parliament for a person to voluntarily provide to the officer documents, data, or information the person is not prohibited by law from disclosing. We know that we can do more. We can track down cyberbullying. We want to support law enforcement. But we always need to bear in mind that our role here as members of Parliament is to hold a government that is increasingly exercising abusive powers in terms of the way in which bills are ran through this House and in terms of the new powers given to the state to intrude into the lives of Canadians. We have continually less respect for civil liberties, more trust in the idea that Big Brother can handle things. I submit that the existing criminal code elements go quite far in giving us the powers that we need, and this bill goes too far.
Questions and comments? Question et commentaires. L'honorable député de Gatineau.
The honourable member for Gatineau. Thank you, Mr. Speaker, and I'd like to thank my colleague for the excellent speech as usual. I'd just like to read an excerpt from a Global News article that I read this morning. The writer normally supports the type of thing the government's preparing to do here, and Marianne Franks, who has made a name for herself fighting revenge porn, etc.
It's almost always a woman, without her permission or knowledge, often by an estranged partner, says something that I thought was pretty interesting, and I would like the colleague to comment. I don't think it's ever going to work to try to protect privacy by invading privacy. So her comment, please.
The honourable member for Saanich, Gulf Islands.
Merci à ma collègue, la députée de Gatineau.
Thank you to my colleague, the member for Gatineau, for her question. I think that she's right, because that's a very interesting quote, and I agree entirely.
Privacy by invading privacy. You'll never get more law and order by putting people in jail when you should be creating the circumstances that keep people out of criminality to begin with. We need to actually think about what's getting passed in this place so that we can ensure that the rights and liberties of Canadians are not constantly whittled away in the creation of greater talking points and slogans for the next election.